Okay, well, welcome everybody to our April webinar. And today we're going to be talking about some major changes that have just come to employment law in the UK and the key actions that employers, particularly small business employers, need to take in light of these changes. I'm Alex. I'm the co-founder of Sprint Law. For those of you who aren't already clients of ours, just a quick introduction to who we are. We're an online legal team really designed for startups and small businesses to manage their legal matters. Unlike traditional firms, we don't charge by the hour. Everything we do is fixed price. We cover most of the areas of business law that small businesses may need help with, everything from helping you set up your business, get key contracts in place, e-commerce, intellectual property protection, data and privacy, fundraising if you're doing that for your business, and as we'll be talking about today, employment law. We have an optional membership, but about 90% of our clients sign up to it, and it's a pretty low cost, really great service for those of you that just want ongoing access to our legal team. You get unlimited quick consultations with our lawyers. There's a platform with free documents and e-signatures tools, sort of like DocuSign, credits to use on legal services when they come up during the year, and our AI, which is about to get a big upgrade that allows you to ask simple legal questions and get some answers. We are a team of a bit over 50. We've been around for 9 years now. As you can tell from my accent, we're originally from Australia, but we've been in the UK for about 5 years, and we are growing very quickly in the UK market. And we've also just launched a new tool at scan.sprintlaw.co. So for those of you, oh, sorry, I saw a comment that the sound is really bad. Is that true for anyone else? If others can leave a comment confirming, that will be helpful so I can work out if it's on my side. Okay, it seems okay for others. Please put a question in the Q&A if anyone else is hearing any audio issues. But it may just be maybe your computer for the person affected. Yeah, thanks. Okay, so we just have released a new tool as well, a free tool. If people want to check it out, scan.sprintlaw.co. You can get your website reviewed by a new tool, and it will find potential legal issues you may have on your website, and also highlight some potential legal issues your business should be thinking about as well for free. So do check it out. And if after this webinar you are in need of any assistance or advice with employment law related issues, we always have a free initial consults with our team who can help point you in the right direction and give you a quote if there's further work that you may need help with. So into the content for today, we will be talking about the changes to the Employment Rights Act that have just been rolled out, passed in 2025 and being rolled out in 2026 and 2027. We'll be talking about what's changed, a bit of an overview to begin with, and then looking at the specific changes, new day one rights that employees have, changes to statutory sick pay, family leave, looking at new changes to harassment in the workplace and whistleblowing. We'll be looking at some changes to trade unions and the way they're regulated. And then at the end, we'll have a bit of a summary of the key dates and the key actions that you want to be thinking about as a business. As I'm going through, we've got the Zoom Q&A feature. Do feel free to drop questions in. I might try and leave some time at the end for questions, but I'm usually happy to answer as we go as well. So feel free to use that feature. So what's going on and what's changed? Well, as you may already be aware, in 2025, there were major reforms passed to the Employment Rights Act in the UK. It's being described by many people as the biggest law reform in a generation, and not because it necessarily replaces everything in the way that employment law works, but it's got a suite of quite significant changes to the existing employment law system. Overall, it's designed to give workers stronger protections. And so for those of you who are employers, you now have additional obligations. In short, and you want to be aware of what they are, and you want to make sure that you're complying with them because employees, workers are now in a stronger position. The rollout is happening in phases. Some of the rollout has happened already in April. There's further implementations happening in October this year as well as in 2027. So some of these things you want to get on top of right away, and others you want to start preparing for as they are rolled out. Here is a bit more of a specific timeline. And again, I'll go through each of these changes in a bit of detail in this presentation. But now in April, since the beginning of this month, we have workers' rights to statutory sick pay from day one, paternity leave from day one. There's a new Fair Work Agency being established as a sort of regulatory body for workers to help understand and enforce their rights. Whistleblowing and harassment, collective redundancy penalties are being doubled, and requirements around gender pay and menopause plans. In October, we have the fire and rehire ban coming, stronger duties around harassment, the trade union changes, and tipping law changes, and time limits for employment tribunals. And then in 2027, we're going to have the changes to unfair dismissal laws, moving that earlier, rights for 0-hour workers, and a few of the other changes listed there. So I'll go through these in detail, but you can see there's really 3 periods in which these things are coming into force, and these are the ones on the left that you want to be thinking about right now. So let's start with the day one rights, and we'll talk about each of these, the new way that unfair dismissal and probation works, 0-hour contracts works, and fire and rehire ban works. So starting with the unfair dismissal and probation, how is this going to change? Well, currently, employees have to work for you for 2 years before they can make an unfair dismissal claim. Under the Act, this is going to change to just 6 months. So that means if you have an employee who is starting with you today, and after 6 months, you want to let them go, you have to ensure that you're following proper processes, documenting their concerns, following fair procedures. If they're found to be dismissed in a way where they sort of weren't treated correctly or reasonably, they can make a claim for unfair dismissal, and you can be liable for payments to them as a result of the dismissal. So that's quite a big change. And again, there was some research that came out showing that the percentage of staff in the UK who were leaving employers in under 2 years was rising, sort of, and so there was a larger pool of staff that weren't gaining any protection of these unfair dismissal laws. So this change is obviously going to affect a very large number of workers, particularly for small businesses. You may have staff that may not work at your business for a long period of time, and now you've got to make sure that if you are dismissing them, you follow proper procedures. So an action here to make sure that if you're hiring new staff, you have very clear probation policies from day one, and make sure that you're aware that if people are going to make it past that 6-month mark, they're going to have stronger rights against you, and it may be more difficult to dismiss them. Another change is to the 0 hours contract. So for those of you who have workers on 0-hour or low-hour contracts, where you're not guaranteeing their hours in any given week, they are going to get some new rights as well. So, and this is something that's quite relevant for small businesses. A lot of small businesses rely on workers who, for cash flow and various purposes, the employer does not want to guarantee a full-time or permanent position with the organization. wants that flexibility to not roster them on if there's not enough work. So that's fine, but a change coming in 2027 is for businesses who are keeping people on 0-hour contracts for a long period of time, but effectively treating them as if they were a more permanent employee, giving them regular shifts, and asking them to regularly work more than their contracted hours. And this is not just for 0-hour contracts, but maybe low-hour contracts. Um, they may have the right, or well, they will have the right to request that the employer lock in their normal working pattern and guarantee it. And the idea here, of course, is that the worker may, in practice, if a pattern emerges where they're only contracted to work, say 5 hours a week, but in practice they're working 20 hours a week, they may come to rely on that employment for income. And if the employer, after a period of time, drops that back to 5 hours, it could have a significant financial impact on the worker. So they have the right to request that their contract's updated to lock in the regular working pattern, and they'll also be entitled to compensation if shifts that were promised are cancelled or moved or cut short. So now workers don't have to exercise this right. They can remain on the flexible contract if they want to. They just have the right, if there is this regular pattern of work emerging, to request that the contract reflect the way that they're working. So if they prefer it, it's okay, but they've been given this right to request it of the employer, if that makes sense. The other change is to the fire and rehire laws, or at least there is a new fire and rehire law. There was some research that came out showing that businesses, and actually in particular small businesses, were, when economic times were tough, would engage in a practice of firing employees and then rehiring them on worse terms. So it's a way of essentially giving them a pay cut. Now, this has been banned basically, and it's automatically considered unfair dismissal if you engage in this practice. There is an exception. It's quite narrowly written if the business is genuinely facing financial difficulties that could have led to insolvency, and that is why they had to do this, to reduce pay. But otherwise, and in those circumstances, the business would actually have to show that if these changes weren't made, they would no longer be able to operate. So and they explored other alternatives. So it's a very narrow exception. So in general, this practice has been banned. So of course, this is no longer an option for any businesses that were thinking of using it, and it will be effective from October this year. So that's the first set of changes. The next section to cover is changes to sick pay and family leave. We'll go through each of these: statutory sick pay, family leave changes, and flexible working. So first, starting with statutory sick pay. So these changes are already enforced from the beginning of this month, 6 April. As it stands now, statutory sick pay is payable to employees from day one of their sickness. Previously, employees had to wait until day 4 before the statutory sick pay kicked in. So that there was sort of a 3-day waiting period. But now employers basically have to start paying statutory sick pay from the very first day that employee is off sick. So for those of you who did not have this policy in place already, many employers were managing this in different ways already. But if you had not been paying from day one, it's already enforced, so you need to be doing it now. There was a lower earnings limit. It's been removed. It used to be the case that very low earners were excluded from statutory sick pay. and particularly part-time and casual workers, and that's been removed. So pretty much all employees are now covered. So there is an action here for everyone to make sure their payroll systems reflect that, and statutory sick pay is being paid to staff. And we've already started updating employment contracts for many of our clients who, previously their contract said things that are no longer lawful about how statutory sick pay works. These should be updated now to reflect the new changes. Similarly, leave policies have changed. Paternity leave has now become a day one right. So previously it required 26 weeks of working somewhere for the right to emerge. Now it's a right from day one of employment. And there was a restriction before on taking paternity leave after shared parental leave was taken, and that's also been removed. Ordinary parental leave is also a day one right. Previously, that required 1 year of service. Bereavement leave is a new right, and it's to be confirmed in 2027 exactly how that will work. But if there's a loss in the family, there will be a right for staff to take leave. Unclear if this will be a paid right or an unpaid right for workers. Similarly, in 2027, we're going to have stronger protections around dismissal for pregnant staff members and those who've just returned from maternity leave, and less ability for employers to reject flexible work requests. And if they're going to do so, they have to state the reasons why and explain why the refusal is reasonable. Now, of course, if flexible work is if non-flexible work is required for the role, for example, it's a construction job or something, there are strong grounds for employers to reject flexible working requests. But depending on the nature of work, employers may be required to allow flexible working requests from staff, or provide a good reason as to why they're not providing flexible work options. We also have changes to harassment and whistleblowing. So we'll go through each of these as well. There's stronger duties on employers in terms of preventing and managing harassment in the workplace, third-party liability as well for harassment, and then protections for whistleblowers now. So starting with the harassment protections, businesses are now required to take reasonable steps to prevent harassment in the workplace. And what the Act's done is significantly strengthened employers' duties around preventing workplace harassment. So as of October, rather than having to simply take reasonable steps, employers have to take all reasonable steps to prevent sexual harassment. And there's going to be some more details in 2027 around what reasonable steps are. But the commentary around this suggests that proactively having policies in the workplace, potentially training for staff on what is considered harassment, and so on in the workplace, and what is acceptable conduct, are things that are going to increasingly be seen to be showing compliance. So it's not likely to just be enough to just be reactive to when this occurs. It will actually likely require employers to be proactive. And again, for those of you with particularly growing teams, this is one of the many areas you want to make sure you're on top of, and you have policies in place and procedures and potentially training. In addition, employers are now going to be liable for the harassment of employees by third parties. So if a customer or a client or a supplier is harassing an employee, the employers will have to take reasonable steps to prevent it. And previously it was unclear whether the employers would have this liability, and a lot of the policies that businesses were implementing were focused on employee to employee issues or in workplace issues. Um, but again, some research came out showing that an increasing number of these incidents were occurring from people in the nexus of the business, but not necessarily in the business. And so now that's um, a requirement as of October for employees to take reasonable steps, and again applies to all types of harassment. Uh, um, in addition, and this is more for larger employers, they're going to be required to publish action plans for gender pay gaps and menopause support. So again, not that relevant to smaller businesses, but shows sort of the direction that this these regulations are taking in terms of requiring policies and documentations to manage these issues. On whistleblowing and NDAs, now NDAs had previously been used as a way of suppressing disclosure of issues such as harassment in the workplace. Sexual harassment is going to become what's called a qualifying disclosure under a new whistleblowing law. So workers who make a sexual harassment disclosure will be protected from being seen to have breached a confidentiality clause in an employment contract and being subject to unfair dismissal. And any NDAs that staff are asked to sign will be invalid to the extent that they contain clauses saying you cannot disclose work-related harassment that you suffer or discrimination. So again, some of these practices were emerging in the workplace where an issue would occur, and part of the resolution involved forcing staff members or asking staff members to sign confidentiality or non-disclosure agreements and not talk about it. And this is addressing that and making that not lawful. So workers are free to talk about these issues and can't be restricted by contract. It is important in employment contracts. Your typical employment contract has a very broad confidentiality clause, and often says you can't disclose anything that may harm the reputation of the employer or may have occurred in the workplace, which is confidential in nature. That broad drafting may inadvertently breach this law, and so again, if you haven't updated your employment contracts since this change, we'd suggest getting them looked at again, and we would be drafting in some changes to confidentiality clauses to make sure that it clearly says this contract is not intended to suppress whistleblowing or for harassment. Now coming to other changes, we have some reforms to the way trade unions work, a new employment tribunal, and tipping and redundancy laws. So I'll just go through each of these. This is largely for larger businesses, but there's new trade union rules affecting businesses. There'll be industrial action ballots. So unions only need more votes in favor than against in order to take industrial action. And previously, there were notice periods of 14 days. They've been reduced to 10 days. Employers also, as of October, will have a duty to inform workers of rights to join a union. So workers are aware of their rights. And if an employer tries to dismiss a worker for taking industrial action, it's now automatically considered unfair dismissal. Previously, there was a 12-week limit, but now that's been removed. And workers are also protected from being treated detrimentally if they decide to participate in industrial action. So something to be aware of in terms of A, letting your workers know that they have this right, and B, ensuring that you're not taking adverse action against staff members who engage in industrial action. There are also a range of other areas that are coming into force throughout this year. So in terms of collective redundancies, and that's where multiple redundancies happen at the same time. The maximum award for failure to consult in collective redundancy doubles from 90 days to 180 days pay. So This is a circumstance where an employer will make a group of employees redundant. They need to engage in a consultation process with the employees to look for opportunities to redeploy them in the workplace and consider other alternatives before undertaking the redundancy, and failure to do so can now have more significant financial penalties for the business. Um, the time limits for staff to make a claim after an incident occurs or after leaving a workplace has increased from 6 months up from 3 months. So workers have a little more time to make a claim to enforce their new rights. In terms of uh, tipping laws, um, employers have to consult with workers before creating a tipping policy and update it every 3 years. So this is uh, yes, to encourage fair disclosure in the workplace. Um, there's some changes to public sector outsourcing laws, which again may mostly be relevant to non-small businesses, as well as a new negotiating body for adult social care being established as well. Yeah, these are some of the other changes, but again, not as relevant to smaller businesses, uh, but worth being aware of. So just to revisit those dates, just so you're across when things are coming into force, as I mentioned, as of now, we have statutory sick pay in effect from day one. Your employees, your workers are entitled to that. Paternity and parental leave. We have this Fair Work Agency being established, the whistleblowing for harassment, the penalties for collective redundancies, all coming into force now for small businesses. We have the fire and rehire ban starting in October, as well as the harassment liability and stronger harassment duties, the trade union access and rights, the 6 month limits, the tipping laws. And then in 2027, we have those unfair dismissal protections coming in earlier, as well as those rights for 0 hour workers to get guaranteed hours, get shift cancellation pay, increasing leave protections, flexible work policy changes, and those NDA changes that we spoke about. So lots and lots of changes, all coming into force. I think the main actions for pretty much any business that has staff or workers are sort of set out on this page. Number one, which I mentioned a few times, is you really want to get your employment contracts checked. Most standard employment contracts that you would be using are likely to need updates uh, to reflect the new way that statutory sick pay works, leave requirements, those NDA clauses I mentioned that may be too broad, and depending on what your business does, clarity around flexible work arrangements and how they work to make sure it's consistent with the new laws. Not as urgent, but if given that unfair dismissal rights are going to be kicking in after 6 months, making sure that your business has proper probation processes is very clear in terms of how probation's managed. If a staff member is not performing well early on, how are you going to document that? Is that mentioned in the employment contract? What are the performance review procedures? And do you give them, a few chances to improve their performance before you dismiss them? Failure to do that stuff for someone that's worked in your organization for more than 6 months could result in liability for your business and an unfair dismissal claim. We, in addition to updating your contracts around new statutory sick pay, you also got to make sure, obviously, that you're actually paying from day one. So whether you do your own payroll or if you use a third-party payroll provider, making sure that you have updated those systems as of right now to make sure people are getting paid if they're sick. If you have any 0 hour workers or plan to hire 0 hour workers, be aware of these new rights that are going to come into force. And if you are planning on giving them regular hours above what they were contracted for, just be aware that if that pattern continues over a period of time, they'll have the right to lock that in. And also, again, if you're canceling scheduled shifts, you may be liable to pay for them as well. Not immediately, that a lot of that comes into force in 2027, but it's relevant now if you're going to be hiring 0 hour workers or you have them in your organization. there's a suite of changes, as I mentioned, to the anti-harassment regime. A lot more obligations of the on employers to put into place measures to prevent and manage harassment policies. So, best practice is to have a proper policy if you don't have one. If your team, if it makes sense for your team as well, considering training, and be aware that again, the definition of harassment is expanding past just stuff happening in your workplace to clients, suppliers, and other individuals interacting with your team. And so you want to make sure that, again, you're aware of that and you have policies in place so that if something does go wrong, you handle it properly and you won't have liability for breaching your compliance obligations. So it is a good time to get legal help on this stuff if you haven't already. Again, maybe just beginning with the employment contract review, and looking at putting into place some of the policies, and also there's some actions there for you, of course, on your internal processes for managing staff, and hiring staff. So that was the majority of the content that I wanted to cover for today. If anyone has questions, I'll stick around and happy to take them in the Zoom Q&A feature. Feel free to ask them. We can spend a couple of minutes on that. So we had a question come in. What does the tipping policy refer to? So that's for like tips in a cafe context. So if your business handles tips, like retail staff, instead of handling it informally, employers have got to have like a clear actual tipping policy. They've got to consult their staff when they're creating it and review it every few years. So it's basically meant to ensure that the way tips are distributed in a hospitality context in particular is fair and reasonable, and certain people aren't taking more tips than others, and all those sorts of things. So again, it's specific to those businesses that sort of receive tips, but yes, it needs to be formalized now. How will these changes affect the appetite of employees to grow their business? Assuming these changes will increase unemployment, does the government have plans to remove some of the burden on companies' shoulders? So yeah, look, it's obviously like a decision of the government to focus more on workers' rights with this set of changes, and it is reducing the flexibility of businesses, particularly small businesses, to be able to manage their operations in doing so. The changes, and depending on what your business does, the impact of these changes will vary from business to business. I would say there was consideration, if you read the sort of discussion around the passing of the regulation around how to balance what these changes were with the ability of businesses, particularly small businesses, to manage the compliance. And most of the changes are designed to be manageable through process adaptation rather than massively increasing the cost for businesses. So it's difficult to say, and I'm not an economist, but it's difficult to say what impact this will have on unemployment. I will say that for small businesses to become compliant, you should be able to manage it with some cost in terms of legal cost and in terms of updating your employment agreements and so on, and putting into place policies, and just having a more robust procedures. So I think it may not have those aspects may not be as difficult as they may seem to comply with, but there are, of course, additional costs in terms of things like statutory sick pay and so on. So yes, that's, I think, how the government's sort of framing it, and they haven't announced any kind of offset package or tax breaks or anything like that. So yes, it may have those flow-on consequences you mentioned for smaller businesses. Okay, another question here. How does service charges and tips we can give fair and clear? We have staff working more years in our restaurant. Some just join, they'll get the same service charge tips. Can we pay more to long-serving staff? Yes, you can. However, yeah, I mean, this law doesn't explicitly say what has to be included in the tipping policy and how it has to be designed. It just really says that it must be fair, it's got to be transparent, it's got to be clearly explained. So you have to design a written policy. It can't just be kind of understood generally in the workplace. Staff should be consulted in putting it together, and then if you have a reasonable justification for giving certain staff members, more senior staff in different positions, staff that have worked there longer, more of a tip or a service charge, that could be reasonable if it's justifiable. So you would just have to make sure that it was documented and rolled out in the correct way. Fantastic. Okay. Well, if there's no other questions, I hope people found this session useful. We do these usually once a month, and sometimes a little more frequently. But if you do need help with any of the issues we covered today, do feel free to reach out to our team. Otherwise, thanks so much for listening, and we'll see you later.